Supreme Court of Uganda at Kampala. Civil Appeal number 16 of 2010 between Mande area, the appellant, and the Attorney General, the respondent. This appeal is from the judgment of Court of Appeal at Kampala, um, dated 16th April 2010, Civil Appeal number 21208. Judgment. Uh, this is a second appeal. Mande area and the appellant sued the Attorney General, the respondent in the High Court for breach of court contract in respect of the hire of motor vehicle uh, to State House. And the High Court gave judgment in favor of the appellant. The Attorney General appealed against the judgment of Court of Appeal to this court against the judgment of the Court of Appeal. Brief facts of the case: the facts giving rise of the appeal are that the appellant trading as countrywide contractors. They entered into an agreement with the State House for the hire of motor vehicle Toyota Land Cruiser registration number 860 UAJ at an agreed price of Uganda shillings 200 per day. The hire was on the self-drive basis, and the contract was effective from 7th March 1998. Only depended on the local purchase order, that is on 31st March 1998. And the vehicle was involved in an accident on Masaka Road. It was towed to Masaka Police Station, where it was kept on 29th January 2000, when it was given the police to one Paul Kagwa, who had its registration card. So the appellant filed a suit in the High Court against the respondent, claiming payment of 174,220,000, being payment of hiring charges at shillings 200 per day from 1st April 1998 to 30th August 2000, when he filed his suit. He also claimed 200 per day from the 30th August 2000, when he filed the suit, till the date of the judgment, return of the vehicle, or payment of its market value, and general damages, interest, and the cost of the suit. The Attorney General defended the suit, denying that he owed the appellant the sum of money claimed, pleading that the motor vehicle hire agreement was terminated on 31st March 1998. The trial judge decided in the suit in the favor of the appellant, but reduced his claim to 666,800,000, and also awarded him damages of 200 at an interest rate of 35% and the cost of the suit. The Attorney General appealed against the High Court judgment, the Court of Appeal, and the appellant also filed a cross appeal against the High Court judgment. So, Court of Appeal decided appeal in favor of the respondent and dismissed the appellant's cross appeal. And the appellant, being dissatisfied with the decision of the Court of Appeal, filed the appeal. So, the apparent grounds of appeal, as contained in the memorandum of appeal, were framed as follows: 1. The Land Justice of Appeal erred both in law and in fact by finding that the contract was frustrated by accident. 2. The Land Justice of Appeal erred both in law and in fact by finding that the burden of proof as to whether the appellant was at fault was on the respondent, though he could have proved it, and the assistance of the police who investigated the accident did not attempt to do so, and thereby arrived at a wrong decision, occasioning a miscarriage of justice. And 3, the Land Justice also appealed in appeal erred by finding that the appellant was notified of the accident. And 4, the Land Justice of Appeal erred by finding that while the vehicle was in police custody for investigation, the State House was not in constructive custody of the vehicle. So the Land Justice also, lastly, appealed erred by failing to clearly pronounce themselves on the respondent's cross appeal. So the appellant prayed that the appeal be allowed, the judgment of the Court of Appeal be set aside, the judgment of High Court be affirmed with the orders that 1. A. the appellant be awarded shillings 200 per day, and from first April 1998 till payment in full. B. Interest be awarded on the principal as found by the High Court from the time of filing the suit till payment in full. And C. Order for the return of motor vehicle payment by the respondent on this market value. Appellant also prayed for the cost of the appeal and the cost of the two costs below. Mr. Brian Otieno represented the appellant, and Catherine Kawa, Principal State Attorney, represented the Attorney General. Both filed written submissions on the Appellant Council urged grounds of appeal in order. He represented them in the memorandum of appeal, and the Respondent Council did so, did likewise. However, I'll consider ground 1, 2, together with ground 3 and 4, together with 5 separately in that order. So ground 1 and 2, the appearance ground 1 and 2 complained that the Court of Appeal erred in holding the contract of hire between the appellant and the State House was discharged by frustration under this general issue of whether the contract was frustrated. Thereby, there are some issues which I consider, and they are whether frustration was pleaded by the respondent in his written statement of defense or in the memorandum of appeal. Uh, Written statement, Land Council for the appellant argued that in his written submission that frustration was not one of the respondent's ground of appeal in the Court of Appeal, or even in the respondent's written statement of defense, and that therefore it was wrong for the Land Justice of Appeal to find that the contract of hire was terminated by frustration when frustration was not pleaded. He supported his argument by citing the case of Interfreight Forwarders Uganda Limited versus East African Development Bank. That's in 1994 EA 117 on the importance of pleadings. In reply, counsel for the respondent supported the decision of the Court of Appeal, arguing frustration was one of the respondent's ground of appeal, envisaged under ground 3, where it is stated that the trial judge erred in law and fact failing to properly evaluate the evidence as a whole and therefore came to a wrong decision. Mm. John J.A., who wrote the Court of Appeals read judgment, stated as follows. In the instance the case contract between appellant and the respondent was terminated by frustration and destruction of subject matter, physical destruction of the subject matter as an instance of frustration, as discussed in the case of Taylor versus Cadwell, that is in 1863, 3 BS 826. If further fulfillment of contract is brought to an abrupt stop by some irresistible and constrainous cause for which neither party is responsible, or the contract shall terminate forthwith, relating this to the instant case. The accident occurred without the fault of either party, since the vehicle was subject matter of the contract when it was destroyed. So the contract was terminated forthwith and the parties were discharged. The burden of proof as to whether the appellant was at fault was on the respondent, though he could have proved it with the assistance of police who investigated the accident and did not attempt to do so. In the course of the cross-examination, Monday area, the appellant in the High Court, counsel for the defendant responding in the appeal applied for leave to amend the written statement of defense because, according to counsel, during her perusal, uh, she had found that the contract was terminated by the parties and there was an element of frustration of the contract. At the point of land trial judge adjourned the hearing to enable the defendant's counsel to supply the plaintiff's counsel with a copy of her proposed amendment of the written statement of defense uh, uh, before the trial judge could make a ruling on her application. However, When the court resumed, counsel for the defendant abandoned the application to amend the settlement of defense. The judgment, land trial judge stated that frustration was not specifically pleaded by the defendant and not framed as an issue of this court termination. Even if it had been, uh, I find that the defendant has, on a balance of probabilities, failed to prove that there was frustration of the higher agreement by concurrency with accident. In the respondent's memorandum of appeal, the Court of Appeal, the respondent's ground against the judgment of the trial judge were as follows. The land trial judge entered in law in holding that the plaintiff was not notified of the accident, and yet he was. Two, the land trial judge erred in law and in fact in holding that while the vehicle was in police custody for investigation, State House was still in constructive custody of the vehicle. Three, the land trial judge erred in law and in fact in failing to properly evaluate the evidence as a whole, therefore came to a wrong decision. So the Honorable Judge erred in law and in fact in awarding an interest of 35% per annum on the plaintiffs, which is excessive. Counsel for the respondent argued in this submission that frustration was pleaded in ground three above. I agree with the land council for the appellant, and frustration of the contract of hire was once a ground pleaded in the response memorandum of appeal uh, in the Court of Appeal. Ground three, in the response memorandum of appeal, the respondent's complained that the trial judge did not properly evaluate evidence as a whole cannot in any way be said to include frustration. The land trial judge was right to say that frustration was specifically pleaded in the responsive written statement of defense, and probably this explains why it was not made a ground for appeal in the Court of Appeal either. I find that the respondent's argument that frustration was included in ground three of appeal to this court to be extremely far-fetched and devoid of merit. In the response argument was to be upheld, the community complaints usually found in several memoranda of appeal of complaints filed in the appellant courts and the judge or lower courts held in law. In fact, by failing failing to properly evaluate evidence would be turned into a ground enough to cover uh, all types of grounds of appeal to prevent this rule 86.1 of the Judicature Court of Appeal rules was made to provided that a memorandum of appeal shall set forth concisely and under distinct heads without argument of narrative on the ground of objection, the decision appealed against, specifying the point which was alleged to have been wrongly decided. In this reinforced the rule 102A of the rule, same rules which provides that no party shall, without leave of court, argue the decision of the High Court should be reversed, except on a ground specified in the memoranda of appeal. And this case, no such ground was specified, and no leave was applied for by the respondent. Therefore, with respect, it was wrong for the Land Justice of Appeal to base their decision, to allow the decision, the response appeal on the ground that the contract of hire was frustrated and thereby terminated when the respondent did not plead frustration as a defense in his written settlement of defense, or make frustration of contract of hire a ground of appeal. Two, we look at whether there was evidence of frustration. In this submission, the appellant urged that even if it were to be accepted that the Court of Appeal was right to decide that the contract was terminated by frustration, even when frustration was not a ground of appeal, till there was no evidence of frustration to lead the court's finding that the contract was frustrated. So, counsel for the respondent, on the other hand, argued that whereas the defendant's pleading did not assure that frustration was pleaded as a defense, evidence was laid on it and submissions were made on the issue. However, counsel for respondent did not show which evidence was laid by the defense to prove that there was frustration of contract. The Land Justice of Appeal held that the contract of hire was discharged or by frustration when the motor vehicle had an accident, and that if it was the appellant contention that it was the driver of the state house who caused the accident, it was appellant's duty to prove uh, it. In their judgment, they stated the burden of proof as to whether the appellant was at fault was the respondent, though he could have proved it with the assistance of police. He did not attempt to do so. With respect to the Land Justice of Appeal misdirected themselves on the law of evidence regarding the party which evidential burden proof that the contract was discharged by frustration, that is section 101, 1 of the Evidence Act on the burden of proof, provides whoever deserves any court to give judgment as to any legal right or liability depends on the existence of facts which he or she asserts must prove that a fact exists. Whether or not on the frustration of contract is a question fact, and respondent had a duty to prove it. It is the respondent who sought really rely on frustration to justify the termination of, the contract. This being so, it was incumbent on the respondent to lead evidence to prove that the contract was discharged by the frustration as uh, as a result of accident. If the respondents reduce such evidence, the burden of proof would have shifted from the appellant to show that the motor accident was not due to frustration as claimed by respondent, but it was a result of fault of the driver of the hire vehicle. See the case of Mrs. C. Divya versus Sietco, CSCA number 24, 1993, and Howard and Company Africa Limited versus Battle, that's 1964, EA 540. In the instant case, the only evidence produced by the respondent was Sergeant Rega, the defense witness, who stated, I was driving about 200 meters behind the convoy when I was knocked by a trailer and the vehicle overturned. The vehicle got damaged. This evidence shows that the accident happened and does not show why it happened or who caused it. Possibility that it was caused by DW2 negligence cannot therefore be ruled out as a result of, as the land judge observed, vehicles do not normally get knocked or overturned when driven with due care and attention. Since the respondent wanted to rely on frustration as a defense, he had a duty to prove it in the case of Howard versus uh, Howard and Company Africa Limited versus Baton. That's Supra Sir Daniel Crowell, JA, stated that the onus of providing frustration is on the party alleging it, and if it is proved, the onus is upon the other party to prove that it was self-induced. This is a correct statement in the law. The respondent failed to discharge its burden of proof, and therefore I respectively agree with the finding of the land trial judge that even frustration had been pleaded in the written statement of defense, there was no evidence to prove it. Whether the vehicle was destroyed, the Land Justice of Appeal stated in their judgment, since the vehicle was subject to matter of the contract when it was destroyed, so the contract was terminated forthwith and the parties were discharged. Counsel for the appellant appealed. mm, Counsel for the appellant complained that there was no evidence that the motor vehicle was destroyed. He argued that the only evidence on the record showed that the vehicle was only damaged, but not damaged beyond repair. Counsel for the respondent supported the finding of the Court of Appeal that the destruction of the vehicle rendered the contract impossible to perform, but did not indicate any evidence which was adduced to lead this finding. So the Land Justice cited the case of Taylor and another versus Cadwell and another for the settled principle that destruction of the subject matter of the contract without fault either party renders the subject frustrated, and the parties discharged from the performance. In the case, the music hall, which was the subject matter of the contract, was completely destroyed by fire. However, in the instant case, the destruction of the motor vehicle is not borne out by any evidence. And the evidence of DW2 was that the vehicle was damaged and towed to Masaka police station. However, damage to a chattel cannot be equated with destruction. In the letter written to the Solicitor General on 10th November 2023, 2003, 203, Exhibit D8, Paul Kagwa, DW3, stated that he removed the vehicle from Masaka police station in July when he testified in court on 11th 205. Almost 5 years later, he stated that he was still keeping the car at his home. This evidence, in my view, is inconsistent with the vehicle having been destroyed. Difficult to perform a contract by one party is not co-frustration of the contract. Taylor versus Cadwell, Blackburn stated that there seems no doubt that there is a positive contract to do a thing not in itself unlawful. The contractor must perform it or pay damage, or not doing it, though it consequences unforeseen accident. The performance of this contract has become unexpectedly burdensome. We have seen some. We have seen above, though, that where the contract becomes impossible to perform, uh, no fault or either party due to some mysterious event that was not anticipated by both parties. The contract will be frustrated, uh, and the parties will be discharged from further performance. Since damages to the car caused the accident was not tantamount to its destruction, it had only rendered the performance of the contract burdensome of State House. There was no evidence. There was no evidence of the destruction of the vehicle, and the Court of Appeal therefore allowed to hold the contract of the hire was frustrated as a result of alleged destruction of the vehicle. Therefore, ground 1, 2 of appeal should succeed. Ground 3, 4, respondent 1, ground of appeal of the Court of Appeal, where was the appellant, was that land trial judge entered in law, fact in holding that the plaintiff was not notified of the accident, Hmm? The Court of Appeal agreed with the respondent and found the appellant was notified of the accident through DW2, and who testified in the court that on the right night when the vehicle had the accident, he telephoned the appellant and informed him of the accident. The appellant dispute this and set aside that the appeal, that Land Justice of Appeal, like by finding the appellant was notified of the accident, is submitted that the Court of Appeal should not have relied on DW evidence because, according to appellant, the trial judge had found DW, which had some untruth in this evidence. Further, that the Court of Appeal should have relied on the testimony of the appellant who stated DW never notified him but came to learn of the accident through his cousin who telephoned him from Masaka. Respondent supported the findings of the Court of Appeal and seemed to have argued that since the evidence argued that the service of the appeal were not being rendered due to accident and the contract of according terminated, it is not clear to me why notification of the accident by the State House today appellant is regarded as important in this case. Whether or not DW2 informed the appellant of the accident, the appellant agreed that His cousin informed him of the accident on the 3rd April 1988. 2 days after the accident, so he knew of the accident in reasonable time, and mkumi mwana akuletele sete nawe. While the Court of Appeal might have held that the appellant was notified of the State House of the accident, it did not say the notification of accident by State House to appellant was the basis of determination of the contract. Instead, the Court of Appeal based itself on frustration to hold that the contract was terminated. It seems to me that argument of both parties concerning notification of the accident came from the mistaken view of notification of the accident by State House to appellant to itself be terminated. Um, the contract of hire created for an indefinite duration, such as one under consideration, would only be terminated by either party giving notice of rendered intended determination of the other, unless the subject matter was destroyed without the fault of the hirer. And contract of hire of a vehicle is one of the contract of bailment, and the Ugandan common law on hire of chattel is similar to that of English common law from Uganda, was laid in Harvard Law of England for tradition race use under hire of chattel. It is stated under paragraph 1850. A hire is a class of bailment and the contract by which the hirer obtains the right to use the chattel hired in return for the payment of the owner of the vehicle hiring. Paragraph 1860 thereof said the hirer must return the hired chattel at expiration of the agreed term, and the obligation applies notwithstanding that the task of returning the chattel has become more difficult or costly as a result of some unexpected event occurring independently of the hirer negligence. But if the performance of his contract to return the chattel becomes impossible because it has perished, this impossibility accuses the hirer, provided it is not raised from the fault of the hirer. Therefore, the respondents, as we saw when frustration of the contract was being considered, the duty of bailee not only to prove that the vehicle was destroyed, but also that it was destroyed without their fault. And the respondent failed to discharge his duty in the both respects. The principle that the hirer must return the vehicle hire unless hire proves that the vehicle was destroyed through no fault of his own. Uh, After the contract of hire is terminated, is well established. However, it is also correct to say that the hirer lost possession and control of the vehicle through the owner's fault, and the hirer would be freed from his obligation to return it. See Charles Douglas Curran versus Parsuram and Heisraj, that's in 1962, EA 19 159. The Court of Appeal in the instant case held that State House was not in actual constructive custody of the vehicle after the accident. It stated it is very clear that the appellant did not appellant did not uh, appellant did not retain the possession of the respondent's car, be it constructive or actual. This is because 31st March, the State House lost control of the vehicle because of it was involved in an accident, and police impounded it to assist the investigation. Also, after police was through with the investigation, 2 years later, the owner, Paul Kagwa, went to police and took the vehicle. Up to now, it is possesses the vehicle since police had it in their custody. The State House did not have control over it. Uh, Therefore, I would find, therefore, um, I would therefore, on the whole, allow appeal and set aside the judgment of the Court of Appeal and modify the order of the land trial judge as follows. The appellant to be awarded shilling 200 per day, 1st April 1998, 29th January 2000, as his lost income, the total amount be discounted by 40%. Interest on the above amount be paid at the rate of 880 from the date of filing the suit until payment in full, when the apparent prayer for the return of the vehicle is declined, and the apparent do apparent be awarded cost to this appeal and the cost in two courts below. This is was delivered on at Kampala this 14th day, November 2001. That marks the end of the judgment.